SJC-12431, Commonwealth v. Melissa Pfeiffer.
Jacobstein, good morning.
Good morning. Rebecca Jacobstein for Melissa Pfeiffer. Because we're there, I can start with the grand jury issue, but I really want to focus my argument today on three different issues, which is that the felony murder conviction was obtained in violation of Ms. Pfeiffer's constitutional rights, that the failure to report a fire is not arson, and that even if the failure to report a fire is a permissible theory of arson, it wasn't permissible here because it was waived repeatedly by the Commonwealth.
Well, with regard to the grand jury issue, isn't this more in the position that Grassi was in, since there's already been a conviction, so arguably any impairment or any problem has been worked out through the trial process?
I mean, yes, theoretically. But in this case, what we have is an objection.
But there was no motion to dismiss, I gather, in this case.
There was a motion to dismiss, yes, the indictment.
Because of the failure of providing grand jury instruction?
Yes, that defense counsel requested. Right, defense counsel requested instructions, and then they didn't do it. And then he asked that they tape the instructions that are given, and then they didn't do that. And then he moved to dismiss because they didn't give the instructions he requested. And so all we're asking for, which is much more limited, is that where defense counsel requests grand jury instructions on the elements, that the elements are unclear from the indictment, that the elements be given to the grand jury.
But I guess the question is, what do we do now? I mean, there was no motion for interlocutory appeal. Case has already been tried.
Generally, this court does do those things prospectively.
Well, if the harm is that the grand jury didn't hear the elements of the crime and we decide otherwise, to your position, that the elements were met, where's your grand jury argument?
I'm sorry.
So if we decide that the elements of the crime were satisfied, so by that nature, the grand jury heard a proper crime, your grand jury argument, just like in the federal, once there's a conviction, grand jury issues go away, and as you probably know, in federal court. So shouldn't we be in that position?
The elements that specifically defense counsel was requesting in this case was that the jury be instructed that the grand jury be instructed that the burning of the dwelling had to be the intention of the fire. Like, she set the fire with the intent to burn the dwelling, not just that it happened to. That was what he was asking.
Right, which is your other argument.
Oh, yes. I mean, I have many other arguments.
Yeah.
And that's where I want to.
Why didn't you get to those?
Great. Thank you. But I wanted to start anyway with my felony murder argument, because felony murder has two intents for all intents and purposes. It has the intent to commit the crime, and then it has the conscious disregard for the risk to human life, and sometimes that's implicit and sometimes it is not. And in this case, that second one was taken away from the jury because the court found that it was inferred or it was implicit by arson being inherently dangerous. And this is unconstitutional because it's violated the jury trial rights and it violated her due process rights with respect to the grand jury. And this is with respect specifically to second-degree murder defendants, because you have a constitutional right to have every element that enhances your sentence to be found by a jury beyond a reasonable doubt. And in this case, the arson which is what they found her guilty of arson, had a 20-year maximum, and then they found that this arson caused the death. But without the finding of conscious disregard, this is not felony murder.
So
and the judge found
all
that.
those cases where we say that issue is a legal conclusion are wrong. Every case where we say that inherently dangerous is a decision for the judge, they're all wrong, because we got a lot of those cases out there.
You do. You have a lot of those cases, but in none of those.
So we got a lot of reversing to do. Yeah.
I mean, I couldn't agree more, but very specifically with regard to my case, no one has. I didn't find a single case where someone raised a ring or apprendi issue in a second-degree murder conviction, right? I mean, the underlying for a life felony, you can get life. but for arson, you can't. And the judge in this case basically changed the intent from a 20-year intent to a life intent without a jury determination, and that is what Ring and Apprendi say you cannot do. And so in this particular, in second-degree murder, second-degree felony murder convictions, you can't have a mandatory presumption of intent because it changes your maximum penalty.
But you can have an inference, couldn't you?
Not
Not an inference, a permissible inference?
maybe, but that's not what we had here. This
Had
is
a-
a mandatory presumption. As to,
But it's not, it's, the inherently dangerous finding is not a fact findings, it's a legal conclusion, isn't it? I mean, no one's, it's not, I mean, I haven't reread the Apprendi cases, but this seems different.
well, I don't think it is. I mean, if you, our cases are of two minds. They say that some things are inherently dangerous, but some things are only sometimes
Yeah, but
dangerous, right? And so it's
setting fire
contextual.
to a house, have we ever said that's one of those tough calls?
I have to say that this court has said that it is inherently dangerous, and it keeps citing back to Matchett, and then Matchett just happened to say it and never cited to another case before. So I'm not saying that arson isn't dangerous. It is, but the question is whether she consciously disregarded the risk of death
But it
in this
doesn't,
case.
it doesn't relieve the Commonwealth of proving the defendant's intent, because the Commonwealth still has to prove the underlying crime, right, with its intent
Right,
requirement.
and that, well, right, they still have to prove that intent, but
Right.
they have to prove conscious disregard for the risk of death in second-degree murder cases, because otherwise they're enhancing a penalty without proof, beyond a reasonable doubt found by a jury. That's the difference in the second-degree murder context, is that they, by not by proving the intent for the arson, but only by proving the conscious disregard, are they proving intent for a life sentence. So they are increasing the statutory maximum by an implicit finding by a judge made by a preponderance of the
So,
evidence.
Ms. Jacobstein, this issue since Apprendi, it's never been raised, because what you're saying, as I understand it, is really not that complicated, which is that the intent to commit the arson has a maximum of 20 years. The felony murder is a life felony, parole eligible, life felony. And the judge, not the jury, is deciding that third element. That's never been raised before?
No, not in our cases. I didn't do a survey of other states, but here, no. And I was surprised by that, but what I thought was that maybe there aren't a lot of non-life felonies that are found to be inherently dangerous, so maybe that's why.
I can turn your attention to the issue of the instruction that the judge gave about that if one negligently or accidentally causes a fire and then willfully and maliciously makes no attempt to extinguish it or report it, that it may still be arson because you can form the intent to commit arson after the fire, even if you did not have that intent at the time. I was looking to the cases cited. Have we ever said that that's arson? I know that in Dung Tran, we said that you can infer the conduct afterward. You can infer the intent at the time from the conduct afterwards. That because Mr. Tran did not make any effort to start the fire, that you can infer that he intended, that relates to the question of whether he intended to burn the house down.
Right, his intent
But-
previously based on prior.
But that's, of course, when he brought in the gasoline can to the fire, to the house. Have we had any cases similar to Levesque in which it's been viewed as arson? Levesque was a manslaughter case.
Right, and the other case that I cite in my brief is Commonwealth versus Black, which is also a manslaughter case, because these seem to be, and those were the only two cases
Well,
I
there's
found that were
Commonwealth
similar.
versus Cali, which is the intent to injure the insurer.
Okay, so I wanted to bring this to the court's attention, so thank you for the opportunity. Actually, which is 26610. It's whoever, it's with intent to defraud an insurer. That is actually the basis where Glenn comes from. But in 1923, which is when the Cali case was decided, there was no malicious and willful requirement in 26610. That was added later. So there was, it's actually, we're not comparing apples to apples. This is apples to oranges, because that said the intent to defraud the insurer could come later, and you didn't have to find willful malicious conduct at all. But no, I think the answer to your question then is no, you have never decided that this is arson.
Now, you say there was reliance on the part of the prosecutor. What reliance on the part of the defense attorney to the prosecutor's representation that they were not going to pursue that second theory? What are you saying the defense attorney could have done had she known that that was not waived?
Yes, so defense counsel was prejudiced for the following reasons. First, I would just like to point out that on page 80 of the 7th transcript, he says that he relied on this in his objection.
He being defense counsel?
Yes, so he said so. So that's the first thing. But here's what he could have done. His argument was, his defense was basically two-pronged. It was, she didn't set this fire, but if she did, she didn't do it on purpose. What his defense needed to be, if this is going before the jury, is she didn't do this, but if she did, it wasn't intentional, but also she didn't, it wasn't an accident either, right? It's like he would have had to change his entire defense. He couldn't have gone with that first one, because he has to say now it wasn't intentional and she didn't fail to report. Because there's a lot of evidence before the jury, and some evidence that's not before the jury, that he could have marshaled in his closing, or that he could have brought out better. For instance, Ms. Pfeiffer left the apartment without calling 911. And she didn't have her phone with her, but when she got outside, she reported it to her boyfriend who was staying there, and someone else called 911. And the fact is that if she had to get out quickly and someone else had called 911, she doesn't need to call 911 too. But this whole thing of events is kind of murky, and the timeline, he could have done that. With respect to how her mental state could have impacted.
But isn't there a problem in that she intentionally sets the first fire? I understand your distinction between setting fire to the clothes and setting fire to the dwelling, but it's not as if she's smoking in bed and accidentally sets the fire and then doesn't call anyone. This is an intentional act. That I have much more trouble with this, given that she intentionally starts the fire. This is not, it's not easy to separate out the two.
I think this is where she was most prejudiced by the failure to have knowledge, is because everything about who she was made this unforeseeable to her and made her responses totally different than what one would expect them to be. And this is all discussed in the expert's testimony about how, as a result of her severe trauma and her cognitive handicaps, right, she has, her processing speed is slow, and her visual response time, like her acceptance of visual information, and then how she responds to it is in the intellectually disabled range.
But those are this is a Lattimore standard, right? Those are jury questions, right?
But
And
again, those weren't brought to the jury's attention. So, I mean, like,
Well, they are
were
brought to-
there,
they
but it wasn't argued specifically with respect to this.
To the
and-
second,
Right, because that was just it wasn't.
but
really,
he's making these arguments in the first theory too, right? Defense counsel is saying because she's slow to process information, she doesn't understand that lighting the clothes is going to light the house on fire too.
well, but
right?
that goes to intent, and I think that they're kind of different, right? I mean, the jury did not convict her of second degree, the third prong malice. So I think, one thing we can infer is that this was meaningful information to them. And So I think that there's every reason to believe that they didn't convict her on the first theory, that they don't believe that she intended to burn that building down. Because there really isn't any evidence of that. I mean, there's the evidence in hindsight, but the evidence as she saw it, not really. She was burning clothes. She was unhappy. So if she had been able to marshal this evidence better, this would have been a key point to her defense and to the closing.
And the DA's statement in response to Judge Locke was something along the lines, it's the starting the fire, not the failure to act afterwards, that's our theory.
Right, they say that then, and then when, at the beginning, for preliminary instructions to the jury, the judge actually specifically says, what about this second theory? And they say they go only with the first theory. They explicitly disclaim it twice, that they're doing this. And there actually aren't, I don't remember more than 2 or 3 cases where there's Glenn, and then there's maybe 1 or 2 other cases where this actually has ever gone forward. I'm not finding it. I'm finding that whenever there is a failure to report or a failure to extinguish or a failure to take action, either that failure to take action becomes involuntary manslaughter, or it's just proof that their intent was originally to cause the fire. But it's just that you can't change your mind later and then have a previous action become a crime. It's just not how it works.
The dialogue with Judge Locke is a little hard to follow because they're really talking about felony murder when they're talking about that part, right?
But eventually,
They're not talking about the particular theories when they're having that discussion.
it segues because, originally they're talking about, is it second degree, is it malice murder, is it felony murder? And then the defense counsel explicitly says, as long as it's the setting of the fire and not the failure to report, and then the judge says, well, that's what I'm hearing, and isn't that correct, Commonwealth? And the Commonwealth says, yes, she intentionally set the fire.
Okay, thank you.
Thank you.
Ms. Tilley, good morning.
Good morning. Good morning, Your Honors. May it please the Court, Colby Tilley on behalf of the Commonwealth. With me is the trial prosecutor, ADA Julie Higgins. I would like to start with the arson instruction. The statute provides whoever willfully and maliciously sets fire to, burns, or causes to be burned a dwelling house is guilty of arson. In this case, and certainly there are cases in which this court has recognized that the intentional failure to report a negligently set fire can form the basis of arson. That is the Commonwealth versus Cali case. There's also
Cali was not an arson case. Cali was an intent to defraud the insurer case.
Yes, Your Honor. However, a part of the intent to defraud the insurer is an arson element to it, that he committed this arson with the intent to defraud the insurer. And my sister indicates that the willful and malicious language didn't exist at that time. I don't have a memory of that. I know that there's a Vellucci case, also intent to defraud an insurer, in which the court was discussing a failure to report. There was no evidence in that case about no one observed the individual setting the fire. They did observe that individual leaving the home, so the jury was permitted to view that flight from the home as evidence that he failed to report or do anything about a fire that had been set in his home.
So if somebody smokes in bed and discovers that they've set the bed on fire and walks away and does not report that crime, they have committed arson?
Yes, Your Honor.
Have we ever said so?
Your Honor,
I mean, in Levesque, of course, it was a manslaughter, was only charged with manslaughter.
That's correct. In Levesque, the court found that there was a duty where the defendants there, as a result of a physical altercation, knocked over a candle. The court found that there was a duty to report the fire that they had negligently set.
So the failure to, you're saying the failure to comply with a duty to report is the same as an intent to burn the dwelling?
It is, Your Honor. You're forming the fire starts, and you're forming the intent at that moment. The fire has now started, and you're watching it engulf the room, and your decision, your willful and malicious intent at that point is, I'm gonna leave, I'm gonna go across the street and just watch the entire apartment building burn down, because I've decided that I have the willful and malicious intent at that moment to let the building burn to the ground.
Which means that in Levesque, they could have charged the man and the woman with second-degree murder, not merely manslaughter.
They could have. They made a decision to charge with manslaughter in that case.
But this case is easier, right? Because we have an intentional starting of the fire. This is not smoking in bed. This is lighting the clothes on fire. So So isn't this just much simpler? And do the two theories really merge? Because you can't separate them.
So it's the Commonwealth's position that theories is really is a misnomer in this case. It's more like prongs, akin to prongs.
Actually, counsel, there's a case from, it was Justice Abrams wrote it in 1998, Commonwealth versus Hunter. It's a first-degree murder case talking about extreme atrocity and the Cunin factors. And there's a bit of a discussion, small, but that was when we wrote 7-page decisions in murder cases.
The good old
And
days.
they talk about theories versus factors versus evidentiary considerations. So this, I'm not sure, rises to the level of a theory under the analysis that's been used in the past. Would this be more of a factor or just an evidentiary consideration, or?
It's varying ways to form the intent, the willful and malicious intent. You can form it when you ignite the fire. You can form it when you willfully and maliciously take no action once that fire has been set. It's describing the same element, intent. It's just varying proofs of evidence as to.
It's really a proof issue.
Yes,
So it's the intent to burn, but the intent is the intent to burn a dwelling.
yes, that is
Which means
correct.
even if somebody else were to set fire and you were to willfully fail to report it, you would intend to burn the dwelling?
There has to, under this court's case law, for arson, there's an intent to act or a willful admission, failure to act, as well as the intent to burn the dwelling. That's from the Van Tran case. It's the intentional act as well as the intent to burn the dwelling.
Let's turn to the prosecutor's representations.
As to the,
Why should the prosecutor be released from his or her representations that the prosecution was not going to pursue that argument?
Your Honor, in reading the motion with Judge Locke, there was a bit of confusion going on as to what the parties were discussing. First of all, a bill of particular trying to confine the Commonwealth to the offers of proof at trial is not what a bill of particulars is meant to do. A bill of particulars is meant to give a reasonable character and nature of the crime. Time, place, manner, means is under Rule 13. It was not meant to restrict the evidence that the Commonwealth was going to offer in order to prove intent. That being said, the prosecutor did say that she intentionally set the fire. The prosecutor also did mention that she didn't report it, that she exited the building, that she locked the door behind her when she exited the building. It wasn't until further pressed by the defense attorney and Judge Locke that there was that discussion about as long as the language makes clear that it's the setting of the fire, and the prosecutor indicates that's correct, she intentionally set the fire. That was always the Commonwealth's position, mind you, that she intentionally set the fire. The question was, how did you prove that intent? What offers of evidence? It was in the Commonwealth's opening statement. During the pre-charge conference, the Commonwealth.
Let's turn back to the motion. I'm turning to page 4 of your brief. Mr. Doyle says, as long as the language makes it clear that it's the setting of the fire, not the failing to act after the fire. The court, that's what I've just heard, Ms. Higgins. Ms. Higgins, correct. She intentionally set the fire, that's our position. Is it not, was it not unfair for Mr. Doyle to understand that the prosecution was not going to be relying on the failure to act after the fire.
Your Honor, even if Mr. Doyle took that statement as we are only moving forward, that she formed the intent to burn the dwelling at the time that she lit the fire, it was obvious from the Commonwealth's opening statement, from all of the evidence introduced, the standard for prejudice from a variance in a bill of particulars is very high under the case law. So when the Commonwealth rested its case and Judge Sanders had a discussion about how she was going to charge in a final pre-charge conference, she indicated that she was going to charge under both prongs of this intent. That was before the defendant presented any evidence in that case. The defendant could have asked for a continuance, could have asked for to call rebuttal witnesses, to recall witnesses if he had. There is no demonstration of prejudice in this case. He was well aware before he presented the defendant's case that this was a theory that was being presented to the jury. I'd point your honors to the Commonwealth's brief, footnote 16, in which Judge Sanders specifically says, so even though everybody knew the Commonwealth was going to be pointing to this evidence that she left the building, she didn't notify the occupants, she didn't call the firefighters, that was evidence that was put on the table early on. Because this wasn't specifically raised in the motion for bill of particulars, it's precluded, is essentially the discussion that was had before the defendant even presented their defense. So in terms of this statement that wasn't introduced to the jury, that the defendant made some efforts to extinguish the fire, it would have, one, been in conflict with her defense had he presented that. The defense was she couldn't understand her actions. If she had taken steps to extinguish the fire, that would have evidenced an understanding of her actions and that it had spread. So I would say that they have not demonstrated a prejudice if there was a variance from the bill of particulars.
Did the prosecutor ask for the instruction at issue?
We did during the final pre-charge conference. There was a pre-charge at the beginning of the case, and we asked for it to track the statutory language. It wasn't in a written submission by the Commonwealth, but the judge had asked if we were requesting the
But you didn't, when you provided the written instructions to the judge,
We did not include
You did
it.
not include it.
We did not.
So does that not suggest that even the prosecution did not think that theory been advanced since it didn't ask the judge to include it?
It does not, since I wrote it, Your Honor, and it was a failure on my part, an omission, and when it was raised by the judge, I realized that I had not included the supplemental instruction from the model instructions.
Well, what is the consequence what if we find that a representation was made, that it was relied upon, and that the judge, sua sponte, effectively changed it by offering to give it? What's the consequence of that?
Again, Your Honor, under the case law, a variance between the bill of particulars, or in this case, a statement by the prosecutor that they were proceeding under one prong of intent, the standard is a very high standard of prejudice under the case law.
Isn't there one other fact, too, which is the judge figures out it should have been given, you guys weren't aware it should have been, but then there's no objection by defense counsel, right, at that point? Is there an objection at that point or not? You say in your brief there was not. I can't actually find it.
During the final charge conference, there was no objection by defense counsel.
So we have, this issue gets raised 3 times.
It does get raised a number of
In the bill of
times.
particulars, the pre-charge, and the final charge. Is it unobjected to the last 2 times by defense counsel? Because that may make a big difference.
Well, so in the pre-charge, the way that it was phrased was that we had asked the judge to track the statutory language. So we did not request that she give the model instruction on arson. We had asked just to track the statutory language.
The judge figures out it's an appropriate thing to do, and the judge is sort of ahead of both counsel, well, maybe at least ahead of the prosecution. But is there an objection from defense counsel once the judge decides the evidence supports both theories?
My memory is that he I can't speak to it. I'm sorry, I don't have
We can look it
a
up.
specific
Well,
memory.
the defense brief says on page 25, defense counsel objected at the charge conference,
Would-
7/204-205, and reiterated his objection both before and after the instruction was given, 8/24 and at 1/24. It's rather important whether or not there was an objection. Are you saying that you can't recall, I mean, that she's wrong, that the
Yeah, I'm not-
citations are incorrect?
I'm not saying that she's
So
wrong.
there was an objection at the charge conference and at,
If we're going to rely on the briefs, the Commonwealth says the opposite in the beginning of their brief, that there wasn't an objection. So I just
all
don't
right,
know
well,
which
we'll
one
have
to
to go to
rely
the
on.
record, obviously, but it's a rather significant.
I believe I'm talking about during the final charge conference. I do believe there was an objection at the close of all of the instructions, just reiterating the objections that had been made throughout the trial is my memory of
I'm just
the
reading
record.
from your brief at page 5. If the Commonwealth asked the judge to track the statutory language. Defense counsel did not object. Hence, the trial judge gave the jury an arson instruction to track the statutory language.
that was during the pre-charge.
Right, pre-charge. You don't talk about in your brief the regular charge. But, so you think there is an objection at the final charge conference?
I believe there is.
Okay.
In terms of, if I can move on to the felony murder instructions, if
I'm sorry,
they're,
but the reference is to transcript 3. The final, this was at the beginning of trial.
yes,
Oh, okay. We're referring to the time.
the final, yes.
Oh, okay. So in the third volume of the transcript, you say there was no instruction, but defense counsel said there was in the 7th volume and at the 8th volume, which is at the end of trial.
Yes. In terms of the defendant's argument about felony murder and inherently dangerous, I just want to kind of offer some historical perspective on inherently dangerous versus conscious disregard. Conscious disregard, from my view of the case law, came about during the Machette case, in which that was an extortion case. It was not traditionally one of the inherently dangerous felonies under the common law felony murder rule. Machette specifically recognized common law felonies such as arson, rape, burglary, and robbery are inherently dangerous, that was a question of law for the judge to decide. I do not believe that rule takes a question of fact away from the jury. For felony murder, it's whether or not you have the intent to commit the underlying felony at common law and whether or not a death occurred during the commission of that felony. The conscious disregard discussion came about when you started expanding to other felonies that are not traditionally viewed as inherently dangerous to human life. So I would say that there is no Apprendi issue in this case, that the judge should not remove an issue of fact
So
from the
should there
jury.
even be an instruction on inherently dangerous? You have an inherently dangerous felony, so therefore there's no issue for the jury to deliberate on conscious disregard for human life. Should the judge even be instructing on that element?
I don't think it's necessary. Traditionally, in the common law felony, it would have been these recognized inherently dangerous felonies. So there wasn't an instruction on my reading until Machette where they were talking about inherently dangerous felonies under law as well as conscious disregard felonies that could qualify under conscious disregard for human life, much like a dangerous weapon per se, as opposed to dangerous as used, where a jury is trying to figure out if something is dangerous as used that's not traditionally known as a dangerous weapon. And if I could just briefly touch on the grand jury issue, if this court would permit. Going back to Justice Gaziano's hypo about the true self-defense, whether or not that had been presented to the grand jury, I think it's important to consider that the prosecution, in their discretion, could not present that case at all to the grand jury. If it was a true case of self-defense, that would certainly be a consideration of the prosecutor, the prosecution's office, about whether or not to even put a case like that before a grand jury to seek an indictment. Certainly, we have ethical obligations to consider whether or not we should be charging a crime. And I would just highlight that to your honors, that there are other things that go into determining whether or not cases are presented to the grand jury that are not before the grand jury.
If I can ask, do we have any record as to what instructions, if any, were given by the prosecutor to the grand jury?
You only have, so it was the practice in Suffolk County at that time to instruct the grand jury on homicide cases. Those instructions are not recorded. I do note in my brief that it was the general practice in Suffolk County to instruct. Then there are the transcript of the grand jury minutes, which you have, which essentially give the statutory language of arson, of murder, of injury to a firefighter. So those are what are transcribed before the court.
So we understand that at least the pattern and practice of the DA was actually to give instructions, even though not required under Walzak, in homicide cases.
Yes, it was. It is the general practice prior to Grassi that instructions were given to the grand jury in Suffolk County, at least.
Okay, but the actual the indictment says that the defendant did assault and beat Crystal Blanchard, who was the upstairs neighbor who was killed with intent to murder her. She actually never assaulted and beat her. She set a fire that caused her death.
Certainly, Your Honor. The instruction requested in this case was an arson instruction. It wasn't a murder instruction.
Well, she was indicted for murder, so the indictment. I mean, the murder indictment is premised on arson.
Well, it's not premised alone on arson. It could have and was charged to the jury to the
As third prong?
Yes, under Commonwealth versus Mello, and so that's how those are the transcripts of what was given to the grand jury. But it was the practice in Suffolk County to instruct the grand jury